Good afternoon, everyone. And before the 25th of December, to understand when we all correlate Christmas with snow, and to understand prior to that, the white collar crime, though on a different connotation, there the snow relates to happiness, cherries on the top and the cake, etc. But white collar crime and blue collar crimes, we all discuss. But the white collar crime of late has picked up like anything. I remember that I appeared in one of the cases. We were discussing a corruption case of a bank employee. The judge says, Mr. Chatra, the corruption case is not too obsolete. You should discuss about scam cases. As long as corruption cases, nobody even bothers how much is there. It is not even mentioned on the first page. Scams to the effect have taken a larger level. It's grown even in the larger scales. And there are various perspectives of the white collar crime. I can discuss on these various perspectives, but as they say, once you have a good resource person who can make you understand better in a simplified manner. So you shouldn't try to step into the shoes, a person who can make you understand in a simplified way. And once the resource person, people want to listen to him. And especially it's a vast subject. And Mr. Bharat has been kind enough, who is an independent counsel, and he needs no introduction as such. He had been a judicial magistrate and then into Duthras and now the independent counsel. I thought that whenever his thoughts were there, he was always independent, but he wanted that on the invite, it should be an independent counsel. I thought that the lawyers, whenever they step into the shoes, even if they are working for any firm, etc., then they forget because they build up their own way of arguments and build up their own case in a subtle manner. Without taking much time, as his name connotes, Bharat, he's not known pan-India, so he needs no introduction as such. And Bharat, you will have to unmute yourself. Over to you. Unmute. Yeah.
Right. Thank you, Vikas, for the very kind introduction. I'll try to measure up and to try for this to be worthy of everyone's time. I was having this discussion, on white collar crime the other day, and I've told somebody that I've been in prison for financial crime. And before that person fell off the chair, I had to clarify that I've been to prison for financial crime while trying those cases as a special judge who used to go to Tihar and, try some of those cases. And there, of course, as a defense counsel and somebody who's had the great fortune of training judicial officers, jail officers, and so on. So today we are discussing an understanding or an overview of what white collar crime is. Let me at the very outset set the agenda for today's discussion. The agenda is a very ambitious one. It's a huge topic. I mean, semesters can be taught on this, and very difficult to summarize all of that in a session of 1.5 hours, but we'll try. So the agenda for today is to get an understanding of what white collar crime is. Where does that term come from? What are the different kinds of white collar crime or socioeconomic offenses? What are the basics of corporate criminal liability, which I think is at the heart of the issue. I'd also like to touch upon the various legislations in India which deal with white collar crimes and socioeconomic offenses, such as the Prevention of Corruption Act, Prevention of Money Laundering Act, Fugitive Economic Offenders Act, Indian Penal Code, and Black Money Act, and so on and so forth. I obviously would not be able to get into the nitty-gritties and the details of all of these laws because of time constraints, but what I'll try to do today is to give you an overview of how these acts function and what are the areas of nuance or the interesting areas in each of these laws and their salient features, so that you have an understanding of what is where, and you'll be able to deal with these situations as they come to you as young lawyers. I'll round off the discussion finally by talking about a few areas which, according to me, need reform, need further thinking as far as white collar crime is concerned. I'll also try to sprinkle the lecture or the discussion with the various strategies that you can adopt as lawyers defending or prosecuting white collar crime cases. What are those peculiar things that you need to keep in mind by defending or prosecuting such a case? in order to make this more relevant to you. And so yeah, that's that. Let's start at the start. I think the first question that anyone would have is, what really is white collar crime? Well, you won't find this term being defined anywhere. It's not that you can pick up a bare act and find it being defined in the statutory dictionary in the IPC or otherwise. It's usually used as a broader term to connote any offense which has a financial motivation, which is done by a person or persons of a certain societal class or position. For instance, executives of major corporations, government functionaries, ministers, people who are in positions of decision making and who wield power, decisions taken by those. And also, a white collar crime is not a crime that involves physical violence normally. So the three things that you possibly need to keep in mind is, one, there has to be a financial motivation. Secondly, done by certain people of a certain societal class and decision-making abilities, and normally doesn't include or relate to physical violence. The term, as we know, was used for the first time by this American sociologist called Sutherland, sometime in the 1939. He used that term in the broad context of so you'd recall that in the 1929s or 20s and 30s, US was going through a Great Depression. And the society, which was really fascinated with business and commerce, was a bit disillusioned because of the things that businesses did at the relevant point of time, and how a lack of regulation led to a huge economic crisis in US. And in that background of disillusionment with businesses and lack of regulation, Sutherland came up with this concept that socio-economic offenses or white-collar crimes have even bigger implications than normal offenses, where there is one victim or two victims. These offenses impact the society at large, and the impact or the consequences, the repercussions are extremely pervasive. And he tried to put the spotlight on these offenses, and he talked about it and led to a discourse on these issues. So what are the broad kinds of white-collar crimes? Insider trading is one, getting some information as a decision maker in a listed company and using that information to buy or sell stock, and using that sensitive information to enrich yourselves. Then there is corruption, taking illegal gratification as a public servant to favor a particular entity, grant a tender to a particular entity who's otherwise not entitled, or taking money for granting a favor as a public servant. Money laundering is another kind of a white-collar crime, very important in today's day and time. The Enforcement Directorate is working overdrive and bringing in a lot of cases these days. I think there's no other statute more important today for a criminal lawyer than PMLA. I'll be touching upon that as well a little briefly. Cheating, forgery, data theft, misappropriation, all of these traditional IPC offenses are also white-collar crime offenses. Offenses such as data theft may also be characterized as a white-collar crime. So wherever the motivation primarily is financial. Let me also clarify at the outset that just because a CEO of a big company is committing an offense, for example, he's driving his car and he hurt somebody while driving in his personal life, that would not be taken to be a white-collar crime just because it's the CEO committing or it's a minister committing that offense. The offense has to have a nexus with position. The offense has to have a nexus with power and the occupation and the power exercise. So just keep that in mind. So this is the broad framework of what white-collar crimes are, what socio-economic offenses are. Why is this a good time to talk about it? I think it's a very, very important time to talk about white-collar crimes because the world is going through a recession, going through a huge financial crisis. And it has been seen historically that in times of great financial crisis, people have a greater motivation or a greater opportunity to commit socio-economic offenses. Warren Buffett said it very beautifully, that it is only when the tide is out that you get to know who is swimming naked. So when the chips are up, when things are going incredibly financially, people do survive, businesses survive, individuals survive, and nobody's taking a tough look at the finances. But when the chips are down, when the tide is out, and when there is a a struggle for a company to stay afloat, when there is a struggle to at least make it to the next quarter, that is where there is a greater opportunity, a greater pressure to commit these offenses. And I think that is the reason we need to have a fresh look at where we are in terms of the law and what is to be expected. I don't want to sound alarmist, but across the world, across financial crisis, these cases have increased. Employee fraud, data theft, accounting malpractices, all of these cases are on the rise. And it's important for us to have this discussion, because the pandemic, not only lays bare the true financial position of a lot of organizations, but also gives opportunity, as I said. Now, I love to approach anything that's got to do with criminal law by taking it back to criminology, at least for a bit, in order to understand what are the motivations of somebody who's a white-collar criminal. Now, on this, I would strongly recommend to everyone this great book that this author has written, Eugene Soltis, on why do they do it, inside the mind of a white-collar criminal. Where he gives us brilliant insights on what are the reasons on why people do it and what are the ways and means in which we can make the law better. I'll try to give you some of those insights here. He examines the question, are people born criminal, first of all? Is a white collar criminal somebody who does a massive fraud? Is somebody who's born with that propensity? Is it something that's there in your genetics or your DNA? Or is it something which is more societal in nature, where you have an external pressure and you are made to commit that offense, or you are somehow the societal forces shape you as a person who would commit that offense? He gets into that discussion. Lombroso, a criminologist at the relevant point of time, a few decades back, used to say that a criminal is not made, the criminal is born. And he used this famous term called atavis, that there are certain people who commit offenses and they are genetically predisposed to commit offenses. And no matter what the societal conditions are, if you have a genetic propensity, if you're born criminal, then you would do it no matter what. And this theory was debunked in the last many decades. People don't believe in that. We genuinely now believe that it is actually the societal forces that shape a criminal. And it is not just nature, or it is not nature, but nurture, which actually is the shaping force behind a personality and which makes somebody act in a certain way or commit or not commit an offense. Then the question comes, why would somebody who's heading a billion-dollar organization, who's one of the richest men or women in the world, is committing an offense to make some more money? What is the motivation? It's clearly not need. You're not stealing bread in order to have the next meal, for example, in a traditional theft situation. This is a situation where you already have a lot. Why do more? So people have done studies into this, and they have come to what is known as the fraud triangle on why people commit white collar crime. Okay. Before I get to the fraud triangle, which is a triangle of pressure, opportunity, and rationalization, these being the three main reasons or motivating factors on why people do it: pressure, opportunity, and rationalization. Before that, it's important to talk about incentives too. In many organizations, in a cutthroat competitive world, employees' compensation and their salaries, more often than not, are linked to their performance if they're able to meet certain targets. And that sometimes, those incentives drive people to cut corners with law, make people not comply with law, somehow make, for example, a person who's in the sales department, he has to meet a particular financial target on sales figures. If he's not able to do it in a particular quarter, he somehow does some, shenanigans with the accounts and tries to put a rosier picture so that he's able to draw his bonus, so that the company is able to retain its stock price, and so on and so forth. So these incentives are important. In today's day and structure, the incentives are such that people have a motivation to do certain acts, looking short-term and not long-term. Somebody said very beautifully, you show me the incentive and I'll show you the outcome. We human beings work on the basis of incentives, and these incentives need to be changed. Another explanation, as I said, of why people do white-collar crime is the fraud triangle. Pressure, as I said, opportunity, and rationalization. Pressure of meeting a target, pressure of a peer pressure, for instance, somebody doing incredibly well as a leader of an organization may still want to do something like this, for instance, commit an accounting fraud with a view to maintain the position that they've achieved and be in that competitive space. These are the pressures. And in times such as COVID, with companies struggling to keep afloat, struggling to protect jobs, there is greater pressure. Opportunity. Second is an opportunity. Now, somebody said this beautifully again, that never let a perfectly good crisis go to waste. So I think many people are, really, white collar criminals are really taking this to heart, and they understand it better than anyone else. Never let a perfectly good crisis go to waste. Now, in these times when all the organizational energies and attention is diverted to somehow saving jobs, somehow avoiding insolvency, somehow surviving during this phase, the attention is not towards compliance. The attention is not towards doing things rightly. The attention is to somehow survive. And when we are looking the other way, there is a lot of opportunity for things to go bad. Another reason why there would be a huge spurt would be in these times especially is because governments across the world are coming up with various stimulus packages in order to, for instance, give relief to a certain sector, or medium and small businesses, or some debt relief scheme, or some bailouts as we call it. And these again give opportunity for people to, for example, forge documents, get these government entitlements and benefits when they don't really deserve it. So again, a greater opportunity to do these things. Also, for instance, the government comes out with a tender of buying masks or sanitizers or ventilators, where time is of the essence and the government has to procure that equipment very, very quickly. And they don't have the time to do their due diligence and go through the normal tendering processes. That also gives a lot of opportunity for people to do fraud, forgery, and so on and so forth. So this is the second part of our fraud triangle: opportunity, pressure, opportunity. Let me go to the third one, which is again extremely important. This is rationalization. We human beings are very good at rationalizing, but we possibly aren't as good at being rational. So a person who commits white collar crime would always have a very good rationalization of why the person is doing it. For example, most of the white collar crimes are committed not by taking a knife in your hands and stabbing somebody. They are committed by changing a number on a spreadsheet somewhere, signing a document, changing a digit on a document, or signing a check in a certain way. And they do not encourage or incite outrage such as a physical violence crime does. For instance, a terrorist attack or a murder in broad daylight, or a sexual assault case. It makes us extremely outraged as people and society on why this is happening, and we need to correct things. But socio-economic offenses, on the other hand, do not arouse outrage because the victims are not visible. The victim is the society at large. The victim is shareholders of a company. The victims are pensioners. The victims are small investors. And when you're doing a white collar crime, the victims are not visible to you. So people are good at rationalizing. Many white collar criminals have said, I just made an entry on a spreadsheet. I was trying to save jobs. I was trying to ensure that the company stays afloat. I haven't killed anyone. These are the defenses or the rationalizations that white collar criminals come up with. The victim is invisible. And that is the reason many white collar crimes are normalized. They do not arouse the indignation of the society as much as other crimes. And that is where we also need to work on it. Gamut or the jurisprudential or the philosophical aspect of what white collar crime is. Let me zero in now on something which is at the heart of white collar crime, which are the principles of corporate criminal liability. Now we all understand that a thing is not a crime unless it is coupled with a guilty intent. Actus facit, nisi mensit rea. An act is not an offense unless it is coupled with a guilty intent. So we understand this is easier to examine in terms of an individual. If you shot at somebody intending to kill that person, it's murder. But how do you examine intent in the context of a company or a corporation? So there we have some principles. For the longest time, it was believed that a company could not be prosecuted for an offense where mens rea or guilty intent is required. But that law has unfortunately has got settled now, and a corporation or a company can also be prosecuted and punished for an offense that requires mens rea. For instance, the company can do cheating now, or a company can do criminal breach of trust. Now, the next question that arises is that the company, since it's a juristic person, how does it really do the offense? It does not have a body of its own. It doesn't exist in flesh and blood. The answer to that question is that there is something known as the acting mind and will of a company. A company clearly is not a natural person. It is a juristic person. It's a legal fiction. It's an abstraction. It's a concept. It's a myth that the law has come up with. It doesn't act on its own. It acts through its people. There are certain people in a company, for instance, the managing director or people at the true positions of power who are the acting mind and will of the company. Their mind, their decisions are the company's mind and company's decision. This is the doctrine of attribution and doctrine of identification, where a company's mind and acts are identified with the acts of its nerve centers, its most important individuals, the managing directors, the executive directors. So it's important for us to see if there is a director or a functionary of a company who's done an act or committed an offense in the course of his employment or in the scope of his duties acting for the company, that act of a managing director or a director can be attributed on the company. Of course, the personal acts of all these directors and employees and agents are not the acts of the company because they are personal in nature. They are not in the scope of their employment. So there, we understand that a company can commit an offense. It commits an offense through its acting mind and will. Take the analogy of a human body. If a company is a body, then the brain is the executive directors, the managing directors. Its hands and legs are its employees and agents. Its conscience are the independent directors. You know, when you study this in greater detail, you'll understand there are executive directors, there are non-executive directors, there are independent directors. Let those independent directors be construed as the conscience of the company. So we have brain, which is the executive director. We have conscience, which is independent director. We have hands and legs, which are employees. And then we have eyes and ears of the company also, which are possibly the non-executive directors. So understand it like that. Another reason why we hold companies to be responsible criminally is the principle of vicarious liability. We understand that anyone who does an act through another is deemed under law to have done it himself. Qui facit per alium, facit per se. He who does it through another is in law doing it himself. And also the Latin maxim of respondit superior. Let the superior answer. So if a director has done something, an employee has done something, acting for the company has to answer, or the company may be made responsible. So these are the principles behind how companies are made liable. Now, the next question is, which should arise in your mind is that, how do you punish a company then? Now you can prosecute the company criminally after Standard Chartered, Motorola, Iridium. They have clarified the law. You can prosecute a company for a 420 charge, for instance. You also prosecute the individuals responsible who took those decisions. For example, in a cheating case, a director who made an inducement or who deceived somebody with a view to get some property may also be made liable as an accused, provided, of course, there are personal allegations and the active role of that director or an individual is also made out. So that's how you'd prosecute a company as well as the individual who are the nerve centers of the company. How do you punish individuals? Those individuals, of course, can be given imprisonment as well as fine. But by the very nature or by virtue of the very fact that the company is not a natural person, you can't send it to jail. You can only impose a fine or a compensation on the company. So this is how you would punish two different people. We've seen a trend where an offense is committed by a company, all the directors as a matter of fact or at the drop of a hat are made accused. There, as defense counsel, of course, we argue day in and day out that you have to make out a specific role on the part of all of those directors in order to make them liable. And just because they are directors, they cannot be made accused in a criminal case for the act of the company unless they have played a specific role in that crime. This is also the decision of the Supreme Court in Sunil Bharti Mittal's case, very landmark decision on corporate criminal liability, where the court examines in detail on how a director's act can make a company liable. But it is not necessary that in every case where the company has committed an offense, the director would automatically be made liable. So the doctrine of attribution cannot be applied in reverse, is what the court has argued. It's a great decision that you should read. I'll share the citation a little later. Now the question is, where does the buck stop? If a company has committed an offense, we do understand that all directors cannot automatically be made liable. You have to make out a specific role, especially if it is an IPC offense. However, there are other special laws where you'll have to do a separate examination. For example, there are certain laws like the Negotiable Instruments Act, or the PMLA, or the Companies Act, or the Food Adulteration Act, where there are specific provisions of vicarious liability. For example, 141 of the Negotiable Instruments Act says that if an offense is committed by a company, any person who was in charge of the affairs of the company or was responsible for the work of the company at the relevant point of time can also be made an accused. Or if there was a director with whose consent or connivance this has happened. So there, if you are dealing with a case under the special laws, then of course, directors can be made accused, but it would always be open for the directors to argue that, yes, you are trying to make me liable vicariously for the act of the company, but I did not play a role. This was not in my knowledge. I did all that I could as a director to ensure something like this doesn't happen. All those defenses would be open to you, either in a 482 petition for quashing of the FIR or a challenge to the summoning order or at a discharge. So where does the buck stop? So you will have to do an examination in every case where a company has committed an offense as to who all can be held liable. Now that you cannot make, for instance, independent directors liable at the drop of a hat, because independent directors are not executive directors who are taking the day-to-day decisions of the company. For example, a non-executive nominee director on the board of a company nominated by the bank, for instance, or nominated by the RBI, is not somebody who can be made liable for something that the company has done, because he's not in charge of the day-to-day affairs. He's not looking at every document and signing. He's only there to exercise a broad oversight on what is happening in the company. So again, if your client is an independent director, a non-executive director, a nominee director, then you would have those defenses open to you. The Ministry of Corporate Affairs earlier this year in March came out with a circular which says and which tells the registrar of companies that you should not prosecute non-executive, nominee, independent directors at the drop of a hat, and unless a role is made out. You would also find favor with section 149 subsection 12, if I'm not wrong, of the Companies Act, which says that normally the non-executive directors would not be liable unless you can specifically prove that they had the knowledge of the criminality, they had the knowledge of the offense by way of formal communication or the minutes of meetings, and so on and so forth. So please look at that as well. Rajesh Kumar Yaduvanshi's decision, I think by the Delhi High Court recently, in the case of a nominee director, is also worth a read. It deals in great detail as to how a nominee director cannot be made liable if the statutory auditors of the company and the other directors have essentially done any wrongdoing, if that nominee director exercised due diligence and tried to find things but could not. So, but there you will always have to examine that person should not, a director should not be willfully blind. Sometimes this is a doctrine that's applied elsewhere, that if you are a decision maker in the company and you are willfully not looking at something wrong that is happening and you're looking in the other direction, then you cannot say when you're prosecuted that you are not responsible, because that is known as willful blindness. So look at that concept as well. This is broadly what I'll say on corporate criminal liability. I'll quickly shift gears to the Prevention of Corruption Act. I mean, just to give you the broad features. You've had excellent sessions on it already. But just to give you a broad overview, we have a new law now, which came into effect in 2018. Now, of course, those offenses are there if you give illegal gratification to a public servant to get a favor or get an advantage. And that obviously remains an offense under Section 7. These would cover your normal cases of bribery. Then there are cases of which are known as trap cases, where a public servant asks for a bribe in order to perform his or her job, and the person has to pay a bribe in order to get it done. But that person informs the CBI or the police beforehand that I'm being asked, or there is a demand of bribe for me, and then a trap is laid down where the public servant is caught red-handed in those cases. So those trap cases still continue to be relevant. Those bribe cases continue to be relevant. We used to have cases of disproportionate assets under the Prevention of Corruption Act, where you cannot pinpoint on the specific bribe that a public servant has taken or a specific wrongdoing that he's done. But you can broadly say that the public servant during his or her career has amassed assets totally disproportionate to their known sources of income. And on that basis, a criminal prosecution used to be initiated. This was there in Section 13 earlier. So that continues even now. The major changes are to my mind, three under the Prevention of Corruption Act, the new avatar. One is that now the scope of criminal misconduct on the part of a public servant has been considerably narrowed. Under the earlier Prevention of Corruption Act, we saw that a public servant could be prosecuted for having taken a decision, which decision benefited some entity, even though there was no proof or allegation of any personal enrichment. So the public servant may not have made any enrichment for himself or may not have made any money for himself, but he has taken a decision which has benefited X or Y, and that seems to be against public interest, then that public servant could be prosecuted. Many of those prosecutions were initiated at the relevant point of time. For instance, in a case where a public servant goes on to give a tender to one company and not the other, or where a public servant thinks that my decision in a given case, for example, a grant of approval for setting up of an industry, the public servant thinks that this is a good decision in public interest, but later, in hindsight, it turns out to be a bad decision. And then that public servant used to be prosecuted with the benefit of hindsight that you took a decision, public interest has suffered, public has suffered a loss, somebody has enriched himself or herself, that is made criminal in the eyes of law. Now, this was deeply problematic on a number of reasons. One was there was no requirement of a guilty intent. There was no requirement of a personal benefit to the public servant. And this led to a situation of policy paralysis or decision paralysis, where a lot of public servants were extremely afraid of taking decisions one way or the other for the fear that they may be prosecuted tomorrow, or they may be their decisions could be questioned later and brought within the purview of criminal law. So that was a problem. And now under the new Prevention of Corruption Act, these type of cases may not be something that can be prosecuted now. And that to my mind, at least, is a healthy departure from the past. Because a delicate, difference is there in a bona fide business decision. For example, a banker giving a loan to a particular industry, and later that industrialist is not able to repay the loan. Then a lot of questions may be asked later that this was a bad decision, this was motivated to benefit that person, and so on and so forth, because hindsight is always 20/20. So those decisions are now reasonably protected. The argument has always been that bona fide business decisions should not be prosecuted, but out and out, corruption cases should be prosecuted and brought to the book. Another interesting, development in the law is the fact that now the bribe giver under the Prevention of Corruption Act can also be prosecuted. Commercial organizations, companies who deal with the public departments or government servants can now be prosecuted if there is any bribery or illegal gratification. This wasn't the case earlier. Now the bribe giver can be prosecuted. The only way for the bribe giver to escape prosecution, I think, are two. One is that the person who gives the bribe now under the new law, within 7 days of giving the bribe, goes to the police and reports the matter himself or herself, and says that I was pressurized or coerced to give a bribe, and now I'm coming out clean and I'm making a voluntary disclosure. And that may be one way you can get a defense or an immunity under the new law. Another defense possible now, and this is peculiar to companies who would face cases under the Prevention of Corruption Act, is the defense of adequate procedures. Under the new law, a company, even if it is a company's agent or an employee doing an illegality or paying a bribe, for example, the company can be made liable, even if it is an agent of the company or an external consultant of the company, need not even be an employee of the company. So companies can be made an accused, but a company can take a defense in the court of law that we had as a company adequate procedures in place to prevent this sort of an activity. However, despite having taken all those precautions, this is something that has happened. And that is a defense for the company. Now, the question that I put to myself after looking at this new scheme is, what are those adequate procedures that the company can have in place? Now, that is something that the government had to lay down on what those adequate procedures are. For example, a compliance department, regular ethical checks, ethical hotlines, whistleblower mechanisms, so on and so forth. What are those adequate procedures is not laid down so far. We hope there would be some guidance, because this would be very important for the companies, because they would conduct their affairs accordingly. They would have very strong in-house adequate procedures to prevent corruption, and they can use that as a defense should they be prosecuted at a later point of time. Another peculiar feature of the Prevention of Corruption Act, of course, is reverse onus. There is no presumption of innocence per se, and it is for the accused essentially to come up with a defense and prove innocence in many of these cases. This is again extremely problematic as a student of Constitution, as a student of criminal law, where you take away presumption of innocence, where you take away due process. It's always problematic. But the provision stays. There are similar provisions under a number of laws which turn the onus of proof on its head and start with a presumption of guilt and not a presumption of innocence. And the accused has to come and prove, his or her innocence. So those are problematic, but those remain, one of the features of these laws. Another interesting feature of the Prevention of Corruption Act, and this is the last on this act, is the sanction for prosecution. Now under the new law, you need a sanction not only for prosecuting the case in the court, you need a sanction even for the purposes of starting an investigation in certain situations. For example, the investigation relates to a decision taken by a public servant. In those cases, you cannot even start an investigation without having a sanction. Now, there are various arguments for and against. I'm not going to get into that debate for want of time. But yes, requirement of a sanction before investigation is quite onerous, because at the end of the day, the authority giving the sanction for investigation, what would it look at if there is no material? Normally, the sanctioning authority looks at the charge sheet, looks at whatever the investigating authority has been able to collect, and then gives sanction. So in many, many ways, this is the catch-22. You cannot start an investigation because there is no sanction. And how would you grant a sanction when you have no investigation and you don't even know what you're dealing with? So those issues, I'm sure would be dealt with and agitated in the courts as we go further. Now, another feature of POCA is that now a sanction is needed for the prosecution of even a retired public servant, which wasn't the case earlier. Earlier, you needed sanction to prosecute only a sitting public servant, but now you need sanction even for retired public servants, which is a good development, because that's how the position is under the CRPC as well, 197 of the CRPC, which talks about a sanction for official acts. So that brings about a parity in law. I'll quickly jump on to the PMLA and a few things that are absolutely intriguing. So PMLA, of course, is something that's keeping most of us extremely busy these days, because ED is possibly the most proactive regulator in the country at the moment. PMLA is a law that gives vast powers to the Enforcement Directorate to attach assets, to prosecute. There are many unanswered questions about the law. Many of those challenges are pending. Just to give you a brief overview on what the framework of PMLA is, it has two components. One is the civil part, where properties which are proceeds of crime can be attached and confiscated. And then there is a criminal part, where ED investigates the offense of money laundering and then prosecutes a person. So there are two broad sections of the Act. The entire, Act is based on the act of money laundering, the act of making some money through an illegal act or an offense, and then laundering that money, or trying to clean that money and reintroducing it into the formal economy. As the name suggests, laundering. You've taken dirty cash, you've taken tainted funds, you've tried to launder them, clean them, put them back into the economy, and then try to portray them as untainted funds, as funds which are absolutely clean and legitimate. That's the offense of money laundering. It is a derivative offense. It does not stand on its own. It goes back to what we know as a scheduled offense. For example, somebody takes a bribe for committing an official act. That money that you've received is proceeds of crime. You've committed the crime, which is bribery. This is the proceeds. And once you've got that bribe and you've tried to use it, you've possessed it, you want to portray it as clean and legitimate money, you've done the offense of money laundering then and there. So money laundering offense, friends, would always be connected to another scheduled offense, which is there in the schedule to the Act. This may be cheating, this may be forgery, this may be fraud under the Companies Act, this may be Prevention of Corruption Act, this may be NDPS, this may be terrorism-related offenses. All of those are scheduled offenses. So there needs to be a primary scheduled offense for the offense of money laundering to come in. Because if there is no offense, then there are no proceeds of crime, because there is no crime in the first place. So those are the nuances of proceeds of crime. The definition of proceeds of crime is extremely, extremely wide. Now, not only can that very property, which is the proceeds of crime, can be attached, but value of that property can also be attached. So that is a bit problematic. Let me give you an example. For instance, in our example, a public servant took illegal gratification for granting a contract. Now, the money received as bribe, let's say 1 million, that is the proceeds of crime, because that is tainted money that you got because of a crime. And what is that crime? That crime is bribery. That crime is Prevention of Corruption Act. Now, this is proceeds of crime. ED can come in, attach those monies with you, whether they are at your house, they can seize them, or if the money is lying in a bank account, they can freeze the bank account. But now, if this person who received that bribe in cash goes on to buy a property with that money, now the ED can come and attach that property also, because that is value thereof. That initial money has changed shape, but it is equivalent in value, and that can also be attached. Now, there are a lot of contentious matters on what can be the value. For example, if somebody's got a bribe today, but there is a property that is there in the hands of a person brought 10 years earlier, can that be attached or not? ED, of course, argues that it can be attached because it is value thereof. The whole point is, if the original proceeds of crime is not attachable or is not found, then go in for something that you can find in order to secure the amount. If that person has a car or a property, go on to attach that. There have been many interpretations of what value thereof for the purpose of proceeds of crime would be. A great decision by the Punjab and Haryana High Court in Seema Garg's case is a wonderful interpretation of the concept, where the court broadly has indicated that the term value thereof for the purpose of proceeds of crime cannot be interpreted so widely or so as to include everything and anything. Because whenever you are trying to attach a property, which is not the original proceeds of crime, you'll have to also understand the possible rights of third parties in that property. For instance, a person who has obtained a car by way of cheating. Now that car is proceeds of crime, but he has sold the car to somebody else who had no knowledge of any underlying criminality, or who had no knowledge of this being proceeds of crime. That bona fide third party who gets that property for consideration, how do we protect their rights? So the judgment in Seema Garg, section 8 of the PMLA, provides an opportunity for that third party also to come and justify that I've got the property by legitimate means, by lawful means, and I should be given that immunity, and the property should be defrozen or deattached. So those things are there. Again, a lot of battles being fought legally. Many of these battles are pending. There's a huge question, and since we are discussing white collar crime, as to whether the offense of money laundering requires mens rea or not. Now, and guilty intent. Should you know that the property that I have is proceeds of crime? Because the offense of money laundering, as defined in section 3 and 4, says that if you have proceeds of crime, you obtain it out of an illegal activity, or you possess it, or you sell it, or you continue to possess it, and you project it as untainted property, then you've committed the offense of money laundering. Maybe you haven't even done the original offense, but just because you possess that tainted property and you know it to be tainted, and you are projecting it as untainted, you have committed the offense of money laundering. So this section 3 and 4, there's a huge debate whether it requires mens rea or not. The jury is out on it. My argument personally, and we've argued this in a number of cases, is that it does require mens rea, because if you look at the section clearly says that it is not only enough that you possess the proceeds of crime, it is necessary for you to project it as untainted property. And you can only project something to be untainted property when you know it to be tainted. So in section 3 of the Money Laundering Act, there is a term used, and, which is conjunctive. So not only do you possess the proceeds of crime, you should project it as untainted. And if you do not have any knowledge of illegality or the tainted nature of that property, then you may not be prosecuted, is an argument that we are making. Of course, the legislature is trying to argue by way of an explanation that they've added that mens rea is not essential. But now again, the debate is going to be whether an explanation to a section can enlarge the scope of the main section, or whether an explanation by virtue of established principles of statutory interpretation can only clarify and cannot enlarge or narrow the scope of the main section. So that is a debate that is being fought or discussed. Then there is a huge difficulty of section 50 of the PMLA, where a statement recorded by the ED during investigation is admissible in evidence, even if you are an accused. This, according to most jurists, is very problematic from the standpoint of Article 20 of the Constitution, where there is a protection against self-incrimination. No person shall be compelled to be a witness against herself. And in a PMLA investigation, the ED can call the accused and compel him to make a statement. So that's again problematic. These challenges are pending in the Supreme Court. Another raging issue on PMLA was that getting bail in a money laundering matter was extremely difficult, because in order to get bail in a PMLA case, section 45, as it stood earlier, said that before the court can release a person on bail in a PMLA offense, the court has to convince itself that the person is innocent and there are reasonable grounds to believe that the person has not committed the offense. That imposed a very high threshold for grant of bail. Normally, a court does not get into the merits or is not expected or required to return a finding on the merits of the case in a bail application. But section 45 of the PMLA made grant of bail extremely difficult, because the accused had to prove at that stage that there are reasonable grounds for believing that I have not done it. He had to prove his innocence at the time of bail, which is absolutely unheard of in criminal jurisprudence, except a few laws such as PMLA, Companies Act, POCA, and so on. This fortunately was struck down, this section, by the Honorable Supreme Court in Nikesh Tarachand's case, Justice Nariman's judgment. But that reasoning has not been taken to other white-collar offenses or acts which impose a similar high threshold on bail. For example, fraud under the Companies Act makes bail equally difficult But that analogy, which Justice Nariman argues, that you cannot turn the presumption of innocence on its head, you cannot make bail that difficult, which is against due process, has not been translated to other laws like POCA or terrorism-related offences or the Companies Act, which is problematic, from a due process lawyer's standpoint. So that's some thoughts on PMLA. We have the time running against us. Another interesting white-collar crime legislation is the Fugitive Economic Offenders Act, which obviously has been passed with certain specific cases in mind. We've had cases of people escaping jurisdiction, owing monies running into hundreds and thousands of crores to public sector banks, going to different jurisdictions, turning fugitive with a view to escape the process of law, with a view to escape the rigors of law in India. Many courts have issued coercive processes, non-bailable warrants against those people, but it was very difficult to bring about their extradition or bring them back to the law. So in order to cater to that or deal with that mischief, the legislature has come up with the Fugitive Economic Offenders Act. The broad salient features are that if a person has committed a fraud or committed a financial offense which involves more than 100 crores as an amount, and that person is not appearing in the court, is not participating in the investigation, and many warrants and coercive processes have been issued against that person, then in order to create that pressure on that person to come back to India to face trial, you can confiscate those properties. And ED has been given the power to make those applications before the special court. And the special court can pass an order declaring somebody as a fugitive and then going on to sanction the confiscation of their properties. So that's another way, another white-collar crime law that is going to be, that is going to be relevant, that is already very relevant. A lot of potential challenges to this law again. For instance, the Fugitive Economic Offender says that if somebody has been declared to be a fugitive under the law, that person can be disabled from filing any civil action in the country. So that right to go to a court, right to get redress for violation of your rights can be taken away from you if you are a fugitive. Now, the government obviously has its justification for such a provision, where they argue that if somebody has evaded the process of law, run away from the country, they should not have the right to use the judicial system of the country to agitate their own grievances when they are not submitting to the laws of the country. So that is the justification for the government, that no right is absolute. Those rights can be taken away on a case-to-case basis. Conversely, the argument, of course, is that right to approach a court for grievance redressal, right to legal aid, right to file a case in the court is a part of Article 21, is a part of right to life. And can that be taken away by a blanket ban such as this or not? And how would the court decide what the disability should be? What makes the disability even more problematic is that if there is a company whose majority shareholder or the promoter is a fugitive, that company can also be disabled from filing an action in a court of law. And that again is open to challenge. And I'm sure we'll have some jurisprudence in this. Another interesting law is the Benami law. Again, the Benami Prohibition Act. I'm sure we should get together and discuss that in greater detail. A very interesting law which penalizes holding a property in somebody else's name while you are the real owner, while you are the beneficial owner, while you have provided the consideration. Just to lay it out, and this can be taken up later, is that for the purpose of Benami law, there is a Benamidar and there is a true beneficial owner. For instance, I buy a property not in my own name, but in the name of a friend, and I provide the consideration. And that friend, who's the name lender, who's the person in whose name the property stands, is only lending the name, is not the real owner. I may be doing it for any purpose. I may be doing it to avoid taxes. I may be doing it to avoid land ceiling law. I may be doing it for any XYZ reason, legal or illegal. But if I've done it, then that person is a Benamidar and I'm the real owner. The law says I cannot go back and claim the property back from that person. In fact, after the new amendments in 2016, I can also be criminally prosecuted if I've done that Benami transaction for the purpose of evasion of taxes or to defeat the claims of my creditors. For example, I'm somebody who's going into insolvency, and I know there are a lot of creditors who I have to pay money to, and I consciously, in order to defeat their claims, buy the property in a friend's name so that they do not recover it from me, or they do not execute the decree that they have against that property. I buy it in some fictitious person's name or a known person's name who's not the real owner. Then I've committed the offense of Benami and I can be prosecuted. So again, under the Benami law also, there is a process of attachment where the income tax authorities can attach those properties as Benami and later also confiscate them. On the criminal side, of course, there is a criminal prosecution. The income tax authorities have been given the power additionally to prosecute cases also under the Benami law. Then you have the Companies Act, a lot of provisions which deal with white collar crime and corporate liability. One of them being 447 of the Companies Act, which deals with fraud. Now, a very fascinating provision, extremely wide. It is meant to deal with frauds that happen in the functionings of the companies or committed by the decision makers in companies. So the 447 of the Companies Act. So that's very interesting, and I take this opportunity to quickly discuss the main problems that I have with this. Very few cases, again, I cannot think of a case where the court has interpreted 447. These are relatively new legislations where we do not have jurisprudence. These cases are still being fought at trial court levels. So there is no clarity on what fraud would be. But if you look at section 447, and let me draw your attention to the explanation. Explanation says what fraud is going to be. It reads, for the purposes of this section, fraud in relation to the affairs of a company or any body corporate includes any act, omission, concealment of any fact, abuse of position committed by any person or any other person with the connivance, with the intent to deceive, to gain undue advantage from, or to injure the interests of the company or its shareholders, whether or not there is any wrongful gain or wrongful loss. Now, extremely convoluted definition. There's so much that's thrown in a single definition. A thing that strikes one, at the very outset is that it's extremely vague, extremely wide. Another problem with the definition is an inclusive definition. And you would find very few criminal laws which are defined in inclusive terms. Section 299 of the IPC doesn't say culpable homicide includes, or section 300 doesn't say murder includes. 405 of the IPC doesn't say criminal breach of trust includes these acts. So criminal laws by their very nature are defined exhaustively. The law has to lay down with clarity and precision what is criminal and what is not. And that is how criminal laws are supposed to be. There cannot be blurred signposts to criminality. A citizen cannot be left or kept guessing on what is criminal and what is not. But 447 of the Companies Act seeks to do this. It defines fraud as acts including these acts which are mentioned in the section, but it may be something else too, which is again problematic from the criminal law standpoint because it's extremely vague. We have seen that vague criminal laws can be struck off by the courts as being unconstitutional. We have the example of Shreya Singhal, where 66A of the IT Act was struck off because it penalized, quote unquote, annoyance. And the court believed that annoyance is extremely subjective. What may annoy one person may not annoy another. And such subjectivity cannot be allowed to get into criminal law, where one investigating officer may differ from this annoyance. Similarly, here, one court may differ from the other on what fraud is, because fraud is not exhaustively defined, not defined with precision. So these are again, some of the areas which are going to be important. And these are my thoughts on this. IBC is going to become very important. Very few people, are looking at the criminal law side of IBC. Now we understand what IBC is and what is the objective to basically revive and give a lease of life to sick companies or companies which are going through financial crisis and revive them. But there are many sections in IBC also which deal with criminal provisions. It lays down offenses. For instance, doing transactions which are preferential and undervalued and fraudulent right before the insolvency is something that is made criminal now. Because it's been seen in experience that if a promoter or owners of a company sometimes know that the company is going into insolvency, many of the assets are siphoned off in that time zone towards insolvency. For example, that 6 months when the promoter knows that the company is going into insolvency, then many assets are given either to related parties, sold at an undervalue, sold at a preferential pricing, or given to somebody where the real promoters are still exercising control. So IBC gives the power for the NCLT and the resolution professional to not only set aside those transactions which are made with the singular motive of defeating the claims of creditors, but these things are also made criminal offenses and with very, very stringent provisions. So that is going to be interesting, that twilight period of wrongdoing where assets are dissipated and siphoned off. There are some very interesting new offenses under the IBC, and we'll see more prosecutions there. And why would we see more prosecutions there? Because that's how people think. There is this on the lighter side, there's this joke that there are 3 promoters and executives of a company who went out for a dinner, and after they've had this very, very lavish dinner, then the question is, who is to pay the bill? And one director says, allow me to pay the bill because I've got a huge inheritance. Very fine. Then the second promoter says, please allow me to pay the bill for the dinner that we just had because my company just got a big investment. Very fine. Then the third guy says, no, please allow me to pay the bill. And then these 2 guys say, why would you want to pay the bill? He says, my company is going into insolvency in the next 2 months. Let me just pay right now. Because right now is the time where I can, use assets the way that I want to for my personal benefit or enrichment or whatever. The claims of the creditors can all take a back seat. So that's the, on a slightly serious note, this is the mindset that we've suffered from. It is important to protect those assets, and IBC provides you, good remedies. Again, something very interesting in IBC is section 32A, which I would urge my colleagues practicing on the criminal side to see. Now 32A of the IBC protects a company under insolvency which has been revived from any criminal prosecution for the acts of its erstwhile promoters. So if you are somebody who's come in to buy a company who was a sick company and you are a resolution applicant under the IBC and you've taken over the company, you've become the new management, you purchased all the assets of the company and you've stepped into the shoes of the company, then the company cannot be prosecuted and you as the new promoters cannot be prosecuted for the sins or for the offense of the earlier promoters. In fact, this provision also goes on to provide protection from attachment of the company's assets, the company which is under insolvency. So very important provision, 32A of the IBC. There are again battles being fought on what is to take primacy between IBC and PMLA, because the Enforcement Directorate believes that it can go and attach a property of a company which is already under the corporate insolvency resolution process, because PMLA has an overriding effect over any other law. IBC, on the other hand, also has a non-obstante clause which gives it overriding effect over any other law. So we have 2 laws which both claim to have dominance over the other and over any other law, and the courts have tried to find out a way on what would have prominence, what would take the upper hand. And section 32A of the IPC is interesting. I don't think I have the time to discuss in greater detail what are the reforms and what is the way forward and what are the things that we should keep in mind as defense lawyers in white collar crime cases. Vikasji, tell me if I have some more, or should we get into questions and answers, because I don't want to cut down on that.
It's fine, or we can have, whenever we can connect with the second part of it.
Understood. So should we?
Because it's already, yeah, it's 1 hour, then we can, though the questions as such have not come, or we can go about the reforms. Let's assume more questions pour in, then I will just give you a hint about it. Because
sure. So I've got some, I can see some questions, but I'll just quickly come to them in 5 minutes.
On the Facebook, but because on the Zoom chat we haven't.
So I think this may be a personally message to me. Maybe that's why. But I'll just quickly,
one question has come right now.
Sure. So I'll just quickly come to it. Just quickly to, in 5 minutes, let me also share a few things which I think are important for practitioners to know. What is it that you can do as a lawyer defending a white collar crime case, and how are these cases different? Now, these are also cases which are like any other criminal cases, but the crucial distinction is that most of these cases are based on documents, based on financial transactions that you need to understand. So a basic understanding of finance, economics, you don't need to be a master at it, but you need to have some understanding of how business transactions work. That can always be learned on the go as well. Another challenge that a white collar crime defense lawyer faces is the challenge of perception. I think when the court perceives it, or anyone perceives a white collar crime case, the sympathies are against you, the tilt is against you. It's very easy to get the court to empathize with a 80-year-old widow who's your client and who's a victim of crime. But it is very difficult for you to get the court to empathize with a corporation. For example, a corporation that is accused of being complicit in a gas leak, or a corporation who's guilty of negligence, which has led to death of many, many people. That's the challenge of a lawyer who's doing a white collar crime defense case, or who's doing a corporate criminal liability case. How do you get the court to empathize with an abstraction, with a legal fiction, with a myth, which is known as a corporation? And that makes your job all the more challenging, but that also makes your job all the more fulfilling. You'll have the opportunity of defending and prosecuting such cases. Of course, you need to be extremely proactive, because in most of these cases, as I said, in the Prevention of Money Laundering Act, Prevention of Corruption Act, there is a reverse onus that is operating against you. You cannot say, as defense lawyers used to perceive it, 40 years back or something, that please stay silent, don't say anything. The prosecution has the burden to prove your guilt and to prove it beyond reasonable doubt. So you don't need to open your mouth during the entire trial. You can, not enter the witness box as a defense witness. You have no obligation to come up with documents. You have no obligation to give specific responses in your 313 statement. All of that takes a backseat. If you are defending your client in a case under PMLA or Prevention of Corruption Act, or any white collar crime offenses, where the court would actively expect you to proactively come and take a positive defense, because you also have to rebut sometimes the presumption that is operating against you. So keep those things in mind. I believe that these cases are on the rise. So whether you are an in-house lawyer, whether you are a prosecutor, you are a judge, you're a defense lawyer, it is important for us to be aware of this area of law. On the legislative side, I think it's important for us to take care of some of the issues that are there in PMLA, which may not be constitutionally compatible. There are some protections that we need to give to the whistleblowers, better incentives. A whistleblower is nothing but an eyes and ears of law enforcement. It is somebody who used to work in an organization, who's seen illegality, and now comes to spill the beans and alerts the law enforcement and becomes a prosecution witness. We need to protect as a system our whistleblowers better. We need to give them better incentives. For instance, there are some incentives for whistleblowers under the Income Tax Act, where you get a part of the amount which has been evaded as taxes. So that we need to incentivize the whistleblowers better in terms of even other prosecutions. We need to have prosecutors playing a more proactive role in investigations of these cases, because investigations in these cases are extremely complicated and complex. And it's good for prosecutors also to become involved at an earlier stage. I understand that under the current system, a prosecutor comes in only at the time of filing of the police report before the court to prosecute the case, but is not actively involved in the investigation of the matter on a day-to-day basis. I think we need certain legislative changes, and I've recommended that separately to the committee working on this, to look into this as well. So that, because many errors are committed by investigators while investigating the case. And those errors in reception of evidence, or collection of evidence, or recording of statements, or forensics can be avoided if a legal mind is involved from a little earlier than that stage. And I think we need to strengthen our plea bargaining structures, give corporations who are willing to come out clean a position of or a provision for leniency, where you can disgorge all the profits and pay the amounts which have been defrauded as fine and compensation, and make those voluntary disclosures. Unfortunately, the present structure of plea bargaining and the system of approval under the CRPC is not very attuned or ready for such a radical interpretation. And I think we need to decriminalize also certain laws. There's too much of a compliance burden. We need to chisel and define our offenses with better precision. As I just discussed the example of fraud under the Companies Act, better and clearer definitions, and a general, an environment of compliance and healthy business. Yeah. Vikasji, should we take the questions now?
Yeah. I have received 4 or 5. Or do you want to take what you have received?
Just give me a second. So Mr. Maulik has put a question to me asking me, can personal assets of directors be attached for an offense committed by the company by imputing doctrine of piercing the corporate veil? Great question. Thank you very much for this. Normal principle is, of course, that a corporation committing an offense is responsible for what it does. There are certain cases, of course, where the corporate veil can be pierced. For instance, cases of blatant fraud, so those, and where the statute allows piercing of the corporate veil. So in those cases where the statute allows it, or it falls under any of the other defenses or established propositions under the common law on when the corporate veil can be lifted, in those cases, on blatant fraud, for example, on IBC had an example of piercing of corporate veil, where we had seen that many people who were the earlier promoters of a company, who had run the company in the ground and could not manage the company properly, come again through a revolving door under the IBC process to buy the same company, but under some other entity's name.
So, Mr. Bharat, only 1 minute, because few would be students also. First, also explain this doctrine of lifting of corporate veil, because a lot of people might not even know, because being a student of law,
I'll do that. Thanks, Vikas. So corporate veil is nothing but the fact that a corporation or a company under the law has a separate entity from the individuals behind it. You read the Solomon versus Solomon, the standard case. Even if a person is pretty much the owner of the entire company. For example, I hold the entire shares in the company, or 95% shares in the company, or 90% shares. The company is still an entity that is separate from me. I'm not the company. The company has an independent legal existence. Proprietorship concern, for instance, doesn't have it. So company is given that separate legal entity by virtue of law. But it is seen in many cases that that independent legal existence or the corporate veil given to a company becomes a matter of abuse, becomes a shield against any accountability, where the promoter says that, or the primary shareholder says that I am not responsible, it's the Companies Act, where the company is nothing but that person. So in those cases, the court, what it can do, and visualize it like this, it can go behind the entity of the company and look at who's sitting behind the veil, who are the shareholders, who are the directors, who are the main people driving the agenda of the company, and then impute liability there. So it can be done in certain cases, but normally not. It is always an exception only.
Yeah,
I got a question by Himanshu. Again, a direct message to me. Has the time now come when we should also equip our anti-bribery laws in align with foreign anti-bribery laws, which inter alia consider private bribery as a criminal offense? That's a great question, Himanshu. I personally agree with this. Many countries, for example, Singapore, also make private corruption something that can be made a matter of a criminal offense or can be rendered culpable. So for instance, a private company which is not a public sector undertaking or otherwise state as per Article 12, and but that company is a listed company and has ordinary people investing in it and has shareholders. If that company does something for a corrupt inducement, for example, grants a contract to another private company on the basis of a bribe, under the present laws, the shareholders can try and say that it is a class action. You have acted in violation of our rights and prejudiced us. But it would not still come within the ambit of the Prevention of Corruption Act, because the Prevention of Corruption Act only applies to public servants and government entities. It's high time where more and more corporations are entering almost all spheres of life. I think investor protection, transparency, accountability, all these things would be better served if we align our laws and also make private bribery something that can be agitated as a separate offense. This is not to say that instances of corruption in private companies as on today are not criminal at all. They can still be brought within the ambit of offenses such as cheating and fraud that we just discussed. And so those can still be made criminal. But I absolutely agree that it's high time that our laws should be aligned with the international best practices. In an increasingly globalized and interconnected world where we are doing business across the world, there is no reason for us not to do that. And that applies not just in case of private bribery. I would say we should also look at the Foreign Corrupt Practices Act in the US. We should look at the UK Bribery Act. These are long-arm statutes which have good extraterritorial jurisdiction also. The new Prevention of Corruption Act tries to proceed in that direction, but doesn't go the whole mile. It was discussed a great deal. One instance, for example, that I can tell you, the whistleblower mechanism is not very strong under the law. We can adopt that. Extraterritorial, jurisdiction is something that we've not been able to sufficiently pin down. Adequate procedures, which I just mentioned in the presentation as a defense to liability for a company, is not something that is defined. There are no guidelines. We have great guidelines for the UK Bribery Act and the FCPA. It's high time that the government looks at those, because at the end of the day, a company needs to know what are the ways or means in which it can prevent these corrupt practices and use those defenses in appropriate proceedings, because there might be a genuine case where there is a bad egg in a company who does a corrupt practice and the company is not behind it, and it is not a collective decision of the company. In those genuine cases where the company is the victim, should be able to take up a defense, and we need guidance there. So I'm completely in agreement with you that we should draw from these laws as well. There is a question.
Abhishek, what are the doctrine of attribution in the white collar crimes in the company matters?
Just give me a second. I can't see this question.
No, he has sent me privately.
Okay, can you say that again?
What is the doctrine of attribution in a white collar crime in cases of company matters?
Sure. So the doctrine of attribution, as I said, is at the very heart of corporate criminal liability. It works in two ways, just to, for everyone's benefit and trying to state it as simply as possible. It works in two ways where the acts, because as I said, a company does not have arms and legs. It cannot do things itself. It has to act through people. So there are certain people who are the mind and will and the body and the heart of the company, or the mind of the company. Those are the people, if they do something, their acts can be taken under law as legal fiction or deemed to be the acts of the company and attributed upon the company. This is what the law permits. Sometimes when a company has done something, the directors can also be made liable, but that has to be provided in the statute itself. There is no automatic liability for individuals. So doctrine of attribution applies in the first situation that I mentioned, but not in the reverse. And in the interest of time, I would just lead you to Sunil Bharti Mittal, which the Supreme Court judgment by Justice Sikri, which deals with this in great detail. I think I have a few more.
Molek says, can personal assets of directors be attached for an offense committed by the company by imputing? Doctrine of piercing the corporate veil.
So this is what I just explained a while back. Depends if you have those grounds where you can pierce the corporate veil. Normal cases, for instance, if you've got a civil decree, for instance, you can execute it only against the company and not go behind. In certain cases, the directors are jointly and severally liable. Let me come back again to the IBC example, where there is something that the previous owners have done which amounts to money laundering. Now the company is in insolvency. Now you cannot proceed against the company because the company in any event is going to the new management who is trying to revive the company, the resolution applicant under the IBC scheme, and the company is being given a fresh start. So the company cannot be prosecuted, the new promoters cannot be prosecuted. But the law says 32A of the IBC that the earlier promoters can be proceeded against personally in terms of their own assets under the PMLA, and their assets can be attached. So there are certain specific provisions that the legislature would provide you from time to time where you can go against personal assets. This is one such case. A normal case of cheating, again, if there are personal allegations, you can go against the director's personal property each time. Under the Companies Act, there are specific liabilities for officers in default and managing directors and key managerial personnel, even in their individual capacity for their own assets. So they're scattered across various laws, but it is definitely possible, but not as it's an exception and not really a rule. Because there is a question by Rajit. I'll take this if that's okay.
I have only one by Azad. It says, why nowadays law enforcement is dependent upon the ruling political parties? For example, Nirav Modi's case, Vijay Mallya's case, sufficient laws to curb corruption. What is your call?
I don't think the question is very clear to me on what is the intent of the question. If you can ask the gentleman to sort of clarify.
You reframe it. Meanwhile, you can take the other question.
I'll take Rajit. What, in your opinion, would it take to reduce the rampant corruption in our country despite so many laws? Transparency International has flagged India as a country where corruption is increasing rapidly. That's Rajit, great question, but slightly outside the brief today. It's a complex problem, hydra-headed problem with multiple manifestations. Very difficult for me to sit here and pontificate on the ways it can be made better. Of course, there are many laws. What we are lacking is proper implementation. I think the certainty of punishment is a greater deterrent than the gravity of the punishment. China has death penalty for a white collar crime. Has the crime stopped? The answer is clearly no. US has one of the highest white collar crime cases in the world, and US punishes these offenses and transgressions very strictly. Bernie Madoff, who did this Ponzi scheme and was defrauded people of millions and billions of dollars, was given a sentence of 185 years of imprisonment. So they have very strict laws, but it hasn't stopped. So what my argument there would be is to have better, narrowly tailored laws where you know what is criminal and you go on and punish it effectively in a time-bound manner, in an effective investigation. And certainty of punishment should be there, that there would be consequences and accountability to what we do, and not just having death penalty, for example, or having a big punishment. So these systemic changes, I did talk about the fact that we need to have an environment of compliance and better whistleblower mechanisms, better witness protection, so that more and more people can come and confess and make disclosures that they've been made to pay a bribe. If a company, for example, wants to come out clean and say that there are certain corrupt practices which were done by the earlier management and we are ready to disclose everything, this is something we've inherited and we are ready to pay fines, we are ready to set our house in order, we are ready to cleanse it internally and have better checks and balances. If those companies are agreeable to make those disclosures and they are ready to disgorge profits, why does our law does not allow those voluntary disclosures? In the US context, companies get into something known as a deferred prosecution agreement or a non-prosecution agreement, where the Department of Justice, which is entrusted with the responsibility of criminally prosecuting those cases, gets into an agreement with a company where the company agrees to make some remedial measures and to change its corporate culture, to change the way it is functioning and not repeat those corrupt acts, and also pay millions and millions and billions of dollars as fine, and then have a fresh start. And those agreements can be entered into, the law allows it. I've seen personally that is a much more effective deterrent than starting a case as we do it here in India, where you start a case but the conviction rates are dismal. So you have started convictions with great fanfare, where you have made a couple of arrests, those have made big headlines, but at the end of the day, you have nothing to show for the results. Most of these cases end in discharge, end in FIR being quashed, end in acquittal. We've had the experience with the 2G cases and so on. So what we need to do is we need to prosecute and investigate our cases more effectively, give opportunities for people willing to come out clean, to spill the beans and pay the fines, and actually recoup the state for the lost cause, and not just initiate prosecutions in a trigger happy way, which we cannot do justice to, and which we cannot take to their logical conclusion. So yeah, some of the ideas on the top of my head.
Yeah. This is by Maulik. If a person solicits a public servant to take a bribe, the public servant wouldn't have taken the bribe. Had he not been solicited to do, can public servant be said to have committed an offence under the POCA?
So it's a nuanced discussion on the section, and looking at the language on whether it would be an offence or not. I think that's slightly outside the brief, I'm afraid. Happy to take this. Otherwise, please write an email to me. We can discuss and resolve this. There are a couple of questions that I have here. One is, this is by Mr. Singh, Mr. Azad Singh. Dear sir, my query is, nowadays law enforcement is, okay, you asked this question. There was a question by Mr. Naveen. I can't see it anymore. Oh yeah, Naveen, Mr. Kumar has asked, officers of banks in India are deemed public under the Prevention of Corruption Act after SC judgment, if I'm right. Mr. Kumar, you are absolutely right. This was Ramesh Gelli's judgment. This is Central Bureau of Investigation versus Ramesh Gelli, 2013, which has held that the officers of private banks are also public servants under POCA. And this is important because although they are not government servants per se, but they do perform a public duty because they deal with public funds. And even in private banks, the funds really are of the people at large. And given the public duty or the nature of their duty, they are taken to be public servants. Now, there is a huge debate that is going on as to whether this concept can be further extended to insurance companies and other PSUs or other semi-government and autonomous sort of departments or not. So, in fact, there was a case that was going on where the question was that the Bar Council of India can be taken to be a public office, and whether the functionaries of the Bar Council of India can be taken as public servants for the purpose of Prevention of Corruption Act or not. I think that's still being agitated. So, yeah.
Yeah. I don't think we have any other question. So,
none from me. Yes.
Yeah. Before we part for the day, tomorrow, Section 227 CRPC, right of the accused to seek discharge by Justice Budal from a former judge of the Karnataka High Court. And since you were talking of IBC, we have two sessions on that. Insolvency and Bankruptcy Code, that is on 26th at 5 p.m. And part 2 would be Insolvency and Bankruptcy Code amendments, that is at 4:30 on Tuesday. So those who wanted just like a sequel, but from a different speaker, they can connect for the IBC. But tomorrow for 227, do stay connected with us. And Bharat, it was a pleasure hearing vast spectrum you have taken up. It was just like a rainbow. You can connect all the dot points and see the all in 1.5 hour session. So it was great connecting. And everyone, stay safe, stay blessed. And Bharat, thank you once again.
Thank you very much.